Good afternoon, everyone. I'm Miriam Lieberman, and on behalf of the Anti-Defamation League, I'd like to thank you all for being here today for the Illinois Supreme Court Candidates Forum. ADL is one of the nation's oldest and leading civil rights organizations fighting racism and bigotry in all forms. Through education, advocacy, training programs, and other means, we strive to protect the civil rights of all people. Today we have a really fabulous opportunity to learn about the experiences, background, and qualifications of candidates for one of our state's most important positions. We wanted to make this as collaborative and inclusive of a process as possible, and so we appreciate all of you who submitted questions for us to ask the candidates today. We determined the order of the candidates standing at the podium and their initial speaking order randomly by picking names out of a hat. And we just want to remind everyone that as a 501c3 tax-exempt charitable organization, ADL is nonpartisan and does not endorse or oppose, any candidates for political office. Any views expressed today may not necessarily reflect the views of the Anti-Defamation League. In addition to thanking all of you for being here, we of course wanted to thank all 5 of the candidates for being here today to give us their time and interest. And we also wanted to thank Sidley Austin for hosting this wonderful event. In addition, I want to thank Lonnie Nassiter, the Regional Director for Anti-Defamation League's Greater Chicago and Upper Midwest area, and the 3 co-chairs for ADL Civil Rights Committee, David Hoffman, Jonathan Quinn, and Marjorie Zesser. David Hoffman will be our moderator for today's forum. David is a graduate of Yale and the University of Chicago Law School, clerked for the United States Supreme Court and the United States Court of Appeals for the Second Circuit. He was also an assistant U.S. attorney in Chicago for 7 years and served as the Inspector General of the City of Chicago for 4 years. Now he is a partner at Sidley Austin, specializing in litigation, internal investigations, and ethics and compliance counseling. And he teaches public corruption and the law at University of Chicago Law School. He serves on the audit committee of the U.S. Legal Services Corporation and recently became one of the co-chairs of Anti-Defamation League Civil Rights Committee. With that, I'm very pleased to present on behalf of the Anti-Defamation League the Illinois Supreme Court Candidates Forum today.
Good afternoon, everybody. Thank you very much for being here. I also want to extend my thanks to the Anti-Defamation League, Lonnie, Miriam, and all the staff who've worked very hard on this for organizing this. I also want to thank my law firm, Sidley, for hosting this, and the great staff and video crew and others who have worked very hard over the weekend to put this together. And I want to thank all of you. This is a fairly extraordinary thing in our view. This ADL and others sent out an invitation on this, including myself, and it sold out. This is a room of about 150 plus people. It sold out in 4 days. We are now streaming live through various websites, including the Chicago Bar Association's website, and will be available for historical viewing on the CBA's website and elsewhere afterwards. And so I take that as a matter of the rock star quality of our candidates and the tremendous interest in the electorate in judicial elections, which sometimes gets poo-pooed, but I think the fact that we have such a great group here says something. You are business and legal leaders, and you are students and everything in between. So thank you all for coming. Thank you to the candidates. It's a very impressive group. I've watched some of the forums in recorded fashion, and sometimes they spar with each other. But it's a very impressive group, and before we get into the questioning and answering and potential sparring, I just want to say how great it is to have everyone here today. You know, people have mixed feelings about electing judges, but we're seeing one potential benefit today, which is that we're fortunate enough to have this fine group of lawyers and judges present themselves and their qualifications to us so that we can educate ourselves and act in a democratic fashion in deciding who should fill the Supreme Court seat. There are only 7 justices on the Illinois Supreme Court, and this election is for a 10-year term. And after a justice is elected for 10 years, they're up for retention for another 10 years. So effectively, in the normal case, it's like a lifetime appointment. I want to thank all of them for their service and their willingness to participate in the process. Let's give them another round of applause, please. Here are the rules. We'll allow introductory statements of 1 to 2 minutes. Do not feel obligated to use all your 2 minutes, but 2 minutes are maximum. Then I will ask questions to each of you. You'll have approximately 1 minute to answer. That will allow a little bit of time for follow-up questions. At the end of that, we'll have time for concluding remarks of approximately 1 minute each. That should allow us to get out of here at about 1:30. Jeremy is the timekeeper, so you can pay attention to him in terms of the cards. I won't be very rigid about the time, but I will gently suggest that it's time to wrap up when you get close to your time. Let's start with the candidate closest to me, Mr. Flanagan, in terms of the order of providing introductory remarks. Mr. Flanagan.
Thank you for inviting me, and I will be brief. A little bit about my background. I was born and raised on the South Side, went to Mount Carmel High School, and then Boston College, the University of Chicago, and DePaul Law School. My father was a postal clerk, worked 41 years at the post office, 42 years actually, night shift mainly. My mother was a secretary, stopped working when the children came along, never graduated from high school because my grandfather died and she had to go to work during the Depression. So I think you'd have to say the United States has a lot of opportunity where you can come from a household like that and graduate from the University of Chicago and other schools like that. Now, why should you vote for me? A couple reasons. I will not take a pension. This state is broke, and it just doesn't make sense for new hires to take a pension. Now, people are already vested, that's different. Now, you probably think, well, that might be a good idea, but why does that get you on the Illinois Supreme Court? I will not take campaign contributions. Let me say that again. I will not take campaign contributions. My wife, who's also a candidate for the Illinois Appellate Court, is the only other one that I know of who can make that claim. I know I've read many times in newspapers and heard on TV many times about the dangers of campaign contributions in judicial elections. If you agree with that, this is your chance. I've also worked in just about every court, from traffic court all the way up to the U.S. Court of Appeals for the Seventh Circuit. I clerked for an Illinois Supreme Court judge when I got out of law school. I've tried many cases, and I've also done quite a few appeals. This diversity of experience, almost all in the private sector except for the judicial clerkship, is something you don't always see with a judicial candidate. I said I'd be brief, and I will be. I'll leave 10 seconds for the next candidate.
Thank you, Mr. Flanagan. Justice Paczynski.
Oh, I'm so sorry. I am Aurelia Paczynski, and I am a candidate for Supreme Court. I'm on the Illinois Appellate Court right now. I am asking people to vote for me for Supreme Court based on my experience not only as an attorney since 1976 in private practice and government practice, and as the clerk of the court, where I was a court administrator of the largest unified court system in the world, but also my experience on the appellate court, where I'm happy to say all but one of my opinions and orders has been unanimous, which tells me that at least two of my well-respected colleagues have agreed with my decision, my research, and my writing. In this campaign for Supreme Court, I have limited my campaign contributions to no money from lawyers who say they are doing appellate work in Sullivan's, to $75 from individual attorneys, no more than $500 from any other individual, corporation, union, law firm, whatever. And I'm very comfortable with that limit. I think in order to stop the problem of citizen cynicism about the judicial process and the big money that's going into it, $4 million campaigns, $1 million campaigns, you have to stop the problem before it starts, and that's what I've chosen to do. You'll also remember that I went to the Democratic Party slate makers and said, you should stay out of judicial races. You should not endorse in the Supreme Court race because we're not allowed to, nor should we, have a partisan platform, and we should make sure that we are not creating the appearance of an impropriety or a conflict of interest. The Tribune editorial, the Degnan debacle, says just about everything. This was a couple weeks ago. People know that partisan politics does not belong in the judiciary. I support elections for judges for reasons like this. You get to kick our tires, see what we're about, ask us questions. That's great. But they should be nonpartisan elections. I have committed my life to public service, and I'm grateful for the opportunity to have done so. I have not lived in an ivory tower. I've been out in the neighborhoods and the communities talking to people, and I value that as a judge and as a citizen, and I hope that people will vote for me, Aurelia Paczynski, for Supreme Court. Thank you.
Thank you, Justice Paczynski. Judge Riley.
Good afternoon. I am James Riley. I'm currently the supervising judge of the probate court here in Cook County. I've been engaged in the practice of law now for 30 years. 15 of those years was out in the southwest side in the family firm of Riley, Riley & Riley. We were the largest family law firm in the state of Illinois for a long time. Out of that, my sister Barbara became a judge, my brother Danny became a judge, and I became a judge. And 2 other brothers are still engaged in the practice of law. While at Riley, I rose to become the president of the Southwest Bar Association, president of the Coalition of Suburban Bar Associations, and a 2-year stint on the Illinois State Bar Assembly. I've been a judge now for 15 years. I started in traffic court for about 1.5 years. During that time period, I left traffic court and would always go out to the suburbs, not the suburbs, but to the branch courts. I then came to probate court. I floated on the probate court for about 2.5 years. And then we instituted a 3rd or 4th disabled adult call. I took that call for about 10 years, and I've been an decedent's judge ever since. And then today, I'm now the supervising judge of probate. During that tenure in the probate courts, I've been instrumental in assisting to introduce, actually, the probate court computer system. It's always in a state of flux. We're told in the next year or so we may go online. We'll be able to get engaged in e-filing and things of that nature. I think the biggest single problem facing the entire legal profession right now are budget cuts, and how the budget cuts will affect court administration, not just the private sector, but the public sector as well. We see state's attorneys being cut, PDs being cut, AGs being cut, court staff being cut, and the delivery of court services is getting to be rather tenuous at best. Thank you.
Thank you, Judge Riley. Justice Cunningham?
Good afternoon. I'd like to thank the ADL and Sidley and Austin for hosting this. I think this is a great opportunity for ordinary people to hear from the Supreme Court candidates. The Supreme Court is the ultimate safety net for the judicial system. And as such, I think it's very important that who sits on the Supreme Court really bring to the table broad experience, deep experience, integrity, independence, and an ability to really listen, to hear, and to function independently. I come to you as a candidate who has been licensed to practice law for 30 years. I was licensed in 1982. And during that time, I have practiced virtually every kind of law there is. And I have also sat on the trial court, the Circuit Court of Cook County, and I have been on the appellate court for the last 6 years. I've also had a great deal of administrative experience, and that's important because the Supreme Court, in its capacity as the overseer for the entire judicial and legal system, has significant administrative responsibilities. And I bring a great deal of administrative responsibility experience to the table. So I think it's important to bring to the table, to the Supreme Court, judges who are independent, who are objective, who come with a breadth and depth of experience, and who have integrity, and who are independent. And so I ask you to support my candidacy for the Supreme Court, and I will leave 30 seconds in my time for the next candidate.
Thank you, Justice Cunningham. Justice Tice?
Thank you, David, and thank you, all of you, for coming out today. As my colleagues have said, we're very pleased to see your commitment to the public discussion. Let me tell you who I am. I began my career, my legal career, as a public defender. For 10 years, I represented indigent defendants. And then in 1983, I became a judge. For the last 28 years, I have served at every level of our court system. For the first 10 years, I was a trial judge, hearing criminal cases, and that is important because about 50% of the Supreme Court's work are criminal cases, and I have about almost 20 years of experience in that area. I also served in the Chancery Division, which of course is where the most complex civil litigation takes place. And then in 1993, I was appointed to the Illinois Appellate Court. I was elected in 1994, and I served there for 17 years. A year and a half ago, when the Chief Justice of the Illinois Supreme Court retired, the rest of the court chose me to take his position. So I have been sitting on the court for the last year and a half. I'm also a leader of the bench and bar. I have been president of the Illinois Judges Association, the Illinois Appellate Lawyers Association, board of managers of both the State Bar and the Chicago Bar. I have been a teacher. My passion is judicial education. I've also taught extensively through the continuing legal education of lawyers as well as law students. I bring a background that includes not only the ability to handle cases because I have had that kind of breadth of experience, but also the kind of administrative experience. The issues that come before the Supreme Court are not new to me. That's the kind of work that I have been doing for the last 28 years, and I ask for your support.
Thank you, Justice Tice. Okay, we'll start with the questions. And just a point of clarification about who we're seeing up here. For those of you who are going to vote on March 20th in the Democratic primary, you only see the names of 4 of these candidates. The gentleman in the middle, Judge Riley, is on the Republican
good side.
ballot and is uncontested, and will have the pleasure of facing off the Democratic winner in November. And the other 4, 2 on each side of him, are the ones who are facing off in the Democratic primary.
That's why I'm in the middle.
I'm going to start with Justice Tice, and then we'll come around to Mr. Flanagan, and we'll stay in that order. Here's the first question. Seeing some of these forums, one of you has said, and I heard it again today, that real-world experience is more important than being in, quote, an ivory tower and talking to other judges and lawyers all day. Tell us about your most important experiences as an attorney before becoming a judge, or as an attorney, and how this has shaped or will shape your approach on the bench. And please feel free to address the ivory tower comment.
I'd be pleased to. I have heard this expression used a number of times in this campaign. I find it kind of amusing that I spent almost 20 years at 26th in California. No one ever referred to 26th in California as an ivory tower before. I spent my life in a courtroom day in and day out in some of the most difficult cases there are. I don't hear my opponents speaking about their litigation experience. You don't hear them talking about trying cases. I participated and was a lawyer in many, many jury trials. That kind of experience, being a trial lawyer and a trial judge, is incredibly important to me as a Supreme Court justice. When I hear these issues, and I've been a reviewing court judge now for 18 years, to be able to understand the context of a trial is very, very helpful in trying to determine these issues. When I see an issue coming up, I say, I want to read the transcript of the jury instruction conference. I mean, I know how trials work because that's the kind of work that I did for a very long time.
Thank you. Mr. Flanagan.
Well, after doing this job for 28 years, there's many memories, and I don't want to bore you with the least interesting memories. I remember when I was a law clerk right out of college, serving process on the West Side. That was before I applied to law school. I knew it was going to be a tough job, and that was good experience. Something that sticks out in my mind is working in Japan. I worked in 2 law firms in Tokyo, and all of that was conducted in the Japanese language. I've been studying Japanese very hard, and what struck me is how similar it was to an American law firm. Going in the door, I thought it would be quite different. It's not. The hours are different, and some of the procedures within the office are different, but law is law, and I was surprised that in such a different culture that the life of a lawyer and the life in the law firm would be so similar.
Thank you. Justice Paczynski.
I think the best thing that I did before I became a judge was to work as the clerk of the court on establishing youth peer juries, and it was the most interesting process, working with 30 suburbs in the city of Chicago and different police districts to set up a program where young people who made some dopey mistake but were not violent, were first-time offenders, instead of getting stuck in the juvenile court system, had a way with their peers from their community to own up to their mistake, acknowledge it, and do some community service to get out of trouble. It was like their get out of juvenile court system free pass, but it wasn't free. The kids were actually harder than probably half of the judges would have been, and the adults were often amazed at that. So I was very, very happy to have a part in that, and if I were elected to the Supreme Court, that would be one of the things that I would like to see expanded throughout the rest of the state. And as a matter of fact, the Illinois Juvenile Justice Commission has also recommended that there be other opportunities for young people who are nonviolent offenders to make sure that we catch these kids early on before they make too many mistakes. And thank you very much.
One quick follow-up. I know you're the one who's said that it's more important to have real-world experience than
Yes.
too much. Can you flesh that out just a little bit in terms of, is that directed at certain candidates? Is that directed at certain experiences? What do you mean by that?
I will acknowledge that serving at 26 in California is not an ivory tower, but it is still not being out in the community. I heard 10,000 domestic violence cases, and believe me, they were not an ivory tower either. But I've spent the past 30 years of my life working with different communities on different projects. Peter Benzinger is here. He knows that I worked on a warrant project when I was the clerk of the court. Being active in communities, getting to know communities. Why? The law should not be different if you're from Lawndale or Glenview. The law is the same. But when you're a fact finder, when you're trying to decide how to interpret what people are saying to you, when you're listening to them, deciding on credibility, knowing different communities is very valuable.
Thank you. Judge Riley.
15 years in private practice here in Cook County. Self-employed. I engaged in litigation every day of my life, usually 2 or 3 courthouses between DuPage, Will, and Cook. DuPage was great because it started at 8:30. So you could get in, get out, and hopefully get back to Bridgeview, Markham, or downtown, or God forbid, Will. That's the real world. When you own your own car and you're putting on 30,000 miles a year going from courthouse to courthouse, that's the real world. And it was private practice. So felonies, misdemeanors, civil, divorce, chancery, probate, county, adoptions, juvenile, we did it all. And we had a first floor location, so we were never in an ivory tower. Many of our clients just walked through the front door, and whatever attorney was there at the front desk got that client. So, but it was the act of not only we had to be a lawyer, you had a bill. You had a bill, you had to mail it out, you had to collect it, you had to do the bank, you had to do your IRS deposits, all of that. That's the real world of practicing law.
Thank you. Justice Cunningham.
Well, let me make the ivory tower disclaimer also. I would never worked in the ivory tower either. I worked for the Attorney General's office initially, and I certainly have tried a lot of cases. I also worked for a law firm where that's all we did. It was a civil boutique kind of litigation practice, and so I've tried many, many cases. But in addition to that, I've been president of the Chicago Bar Association, which those of you who have had bar leadership positions, you know that that's a great deal of administrative work. Additionally, I've been on the appellate court for 6 years now, and in that capacity, I have an opportunity to participate in judicial education, which I think is very important. And over the course of my legal career, I've certainly spent a great deal of time in legal education, being adjunct faculty at 3 local law schools. So I think that it's important to bring a diverse practice experience to the Supreme Court, not only in practice, but on an administrative level. Thank you.
Thank you. Clear ivory tower bashing there across the board. I think that's understandable. Here's the next question. The major bar associations have now come out with their evaluations. Evaluations which are the result of detailed study and interviews by attorneys who have experience and expertise in judging judges. Some would say that citizens should inform themselves about these recommendations and then should follow them. I'd like to give each of you a chance to address that view and the specific evaluations. And I'll start with you, Mr. Flanagan. Mr. Flanagan, you were found not qualified or not recommended by all 3 major bar associations, the Chicago Bar Association, the Chicago Council of Lawyers, and the Illinois State Bar Association. The Chicago Council of Lawyers said that, quote, he is considered to have good legal ability, but a successful candidate for the Supreme Court should have a broader range of experience and must demonstrate the analytic thinking through either work as a trial or appellate court judge or comparable experience. And I want to give you the chance to address that.
Remember, I was never appointed a judge, and that's one of the ways to get experience as being a judge. You might remember the song from the 60s, I've looked at life from both sides now. When I ran for the circuit court 4 years ago and 2 years ago, I had very good ratings. I think it was 11 out of 12 either gave me a thumbs up, or I think 2 actually found me highly qualified. When I ran for the Illinois Supreme Court this time, it was really the opposite. I think there's a danger if you let the bar associations decide for you that you've really outsourced the job of the voter to the bar associations. There's nothing in the Constitution about bar associations selecting judges or recommending them. I'm not saying disregard it. Sure, look at it, but make up your own mind. I'm qualified to do this job no matter what the bar associations say.
Thank you very much. Justice Paczynski.
I believe...
And I'm going to do
I'm
the
sorry.
same lead-in for everybody, so to be fair. You were found qualified by the Chicago Bar Association, but not qualified by the Chicago Council of Lawyers and the Illinois State Bar Association. The Chicago Council of Lawyers said that, quote, many respondents questioned her knowledge of the law, although most praised her temperament. Some respondents were concerned that as a trial judge, she continued to play an advocacy role and questioned whether she could be impartial as a judge. And I want to give you a chance to address that.
I will specifically respond to that first by saying the Chicago Council of Lawyers, I respect them. I don't agree with them, obviously. And I appealed that decision, and I pointed out that looking at my opinions and my orders, unless they could find something that they thought was just totally dopey in any of those, that was the best precursor of the work that I would do at the Supreme Court, and all of those opinions and orders except one was unanimous. So in terms of advocacy, I've never advocated for a specific litigant, but I will continue to advocate for a process that's fair. For example, making sure that senior citizens who are victims of domestic violence get extra services. For example, making sure that homeless people who don't get mail somehow get notice of adverse administrative actions by Illinois agencies. The process to me is something that judges should advocate about, perhaps internally, perhaps externally, but perhaps among our colleagues, but certainly we need to be aware of the process, and I will continue to do that. I don't think the Chicago Council of Lawyers agrees with that, but I was delighted to respond to that challenge, and I ask people to take that into account when they look at my record as not only an administrator, but as a justice on the Illinois Appellate Court.
Thank you very much. Judge Riley, the Chicago Bar Association and the Illinois State Bar Association found you qualified, but did not give you its higher rankings, and the Chicago Council of Lawyers found you not qualified. Both the CBA and the Council of Lawyers praised you for your integrity, work ethic, and decisiveness, but the Chicago Council of Lawyers said, quote, his judicial experience has been narrow. He has demonstrated skills that would make him a good circuit judge,
Thanks.
but a Supreme Court justice requires a broader understanding of the law. I'd like to give you a chance to respond to that.
I like to take the Chicago Council to task, obviously. I freely submitted all of my credentials to the bars. This is probably my fourth time. I was found qualified for circuit court judge 16 years ago. I've been through 2 retentions, found qualified by everybody. The only thing I can assume is that with 3 of the candidates coming from the appellate court, they somehow believe you have to be an appellate court judge before you can run for Supreme Court, and I disagree with that position. So I think my credentials speak for myself. I bring balance more than anybody on this podium up here. 15 years in private practice, 15 years on the bench. I'm currently supervising judge of the probate division. I oversaw the institution of the implementation of the computer stuff. I'm competent in every phase of law. I've tried cases in every division in Cook County. I've tried cases in about 6 different counties. Nobody up here is saying that other than myself. So the depth of my experience, I believe, is very deep. I'm just not an appellate court judge. So,
Thank you very much. Justice Cunningham, the Chicago Bar Association gave you its highest ranking, highly qualified. And the Chicago Council of Lawyers and the Illinois State Bar Association gave you their second highest ranking, but only gave their highest ranking to Justice Tice. The CBA said you were, quote, hardworking and well-regarded for your legal knowledge and broad range of practice and judicial experience. And the Chicago Council of Lawyers said you received praise for being a good practitioner and solid, hardworking jurist with good legal ability and temperament. These are very good evaluations. But in deciding how to vote, should voters instead choose Justice Tice because she received higher evaluations?
Well, using that logic, I think that would disenfranchise voters. It would mean that whoever is selected as the interim appointee would always have the upper hand, and I don't think that that's what the Constitution contemplated. I agree with the Chicago Council of Lawyers comment that a Supreme Court justice should have broad experience, and that's what I bring to the table. And Justice Riley said he was the only one that tried cases in lots of different counties. That's not true. I have also tried cases in many different counties around Chicago, around the Chicago area, before I became a judge. So I think that the Bar Association ratings, and I know they work very hard, but if the barometer is that you have to have already been seated on the Supreme Court, you will always have an unlevel playing field, so to speak.
Let me ask one quick follow-up before I get to Justice Tice. On this issue of interim appointee, and I'll just ask this to Justice Cunningham. I know this has come up. In the future, should there be an interim appointee if a Supreme Court justice resigns? Should we continue with the current system of having an appointment of an interim appointee, or should it be vacant, as it is on the U.S. Supreme Court, until it's filled in a more official fashion?
Well, you know, that's a tough call because there are only 7 justices on the Illinois Supreme Court, so it's a very difficult call. But I think that maybe there should be a more open process in terms of who becomes the interim appointee so that others can submit their names and so that it's not a single choice that's then ratified by the other 6 justices. So I think it would not be good to leave it vacant, but I think the process should be more open so that it doesn't appear to the public to be an insider arrangement.
Justice Tice, you received the highest rankings from the Chicago Bar Association, the Chicago Council of Lawyers, and the Illinois State Bar Association, and high praise in their descriptions. The CBA said that you were, quote, highly respected for your legal knowledge and experience, outstanding temperament, and unquestioned integrity. And the Chicago Council of Lawyers said you were fair and even-handed to all parties appearing before you, and were praised for being exceptionally hardworking and for opinions that are well-reasoned and well-written. In light of those evaluations, I struggled to craft a difficult question for you in this panel. But let me point out that outside the world of bar evaluations, you did not receive the endorsement of the independent voters of Illinois, which endorsed Justice Cunningham. Number one, are the Bar Association evaluations the most important information we'll receive in this election, and should the voters follow them? And number two, given the importance of independence in the judiciary, should the voters instead follow the IVI's endorsement of Justice Cunningham?
I have very high regard and respect for the organized bar, as I've been active in it my whole life. Some of my opponents, one of my opponents, in fact, has challenged the integrity, actually, of the bar associations because of the ratings she received. I am very proud that the Chicago Council of Lawyers, which was created to be the independent voice among the bar associations, when they did their evaluation of every single candidate that's running for any level of the court, and I'm sorry to tell you folks, but there are about 130 candidates who are running for judge at some level in our county this time. I am the only one of 130 that they gave this high rating to. So it has significance. You asked me to compare it to other organizations. I know, as I'm sure many of you know, the kind of investigations that the bar associations use, the intense evaluations, the phone calls, the hours and hours of work that lawyers do to develop these. I do believe the bar associations have more validity than perhaps an organization where if you are purchased a membership, you get to vote.
Thank you very much. I'm going to now turn to a question about electing judges, and I'm going to start with you, Justice Baczynski. Here's the question with the preamble. We can probably agree that of our three branches of government, the branch that must be most independent is the judiciary. Yet electing judges creates a special threat to their independence when we see substantial campaign contributions and potentially large independent expenditure campaigns. This is especially true after Citizens United, which removed virtually all meaningful restrictions on independent expenditure campaigns. And by the way, this was just in the New York Times the other day, in the 2 years since Citizens United was decided, the Supreme Court's public approval rating has fallen from 61% to 46% this past fall, according to Gallup. Illinois almost decided to stop electing judges during the debate and referendum surrounding the 1970 Constitutional Convention, but with a push from then Mayor Richard J. Daley, judicial elections were kept. 2 years ago, my colleagues and I on the Illinois Reform Commission recommended that because of the importance of an independent judiciary, a system of public financing should be instituted for elections for the Illinois Supreme Court and perhaps for the appellate court. So here's the question. Based on your experience in this campaign, what's the right way to do this? Elections as is, elections with public financing, or something other than elections? And I ask you to be specific, and if you choose the public financing option, explain your recommendation for how it should be funded.
Okay. Something different, but not something different than public financing. I think public financing is a bad idea, but I do think that there should be limits on campaign financing to judicial candidates. I think that all contributions and bundlers should be disclosed, and I think the judges need to be responsible for knowing who gave them money so they can acknowledge it and tell the attorneys, you know, this attorney gave me money, so you guys go figure out what you want to do about that and come back to me. I think the biggest problem, though, we had a campaign, a $4 million campaign downstate, a retention campaign, $4 million. We have a campaign in this county, in this race, where one of the candidates received $60,000 from one law firm. Now, you connect the dots. I don't need to. I think that electing judges is important because when I go out and I talk to people, when I get a chance to meet a room full of real voters, it's fabulous. You get a chance to see us. We get a chance to know what you think is important so we can reflect the character of our community. But I do not think that public finance is the right idea. I think that limiting campaign contributions in nonpartisan judicial elections would work much better.
But how would you do that in light of Citizens United, which basically allows for unlimited independent expenditures, including in judicial elections?
Well, you could do it the way I did it, which is to self-limit. I just said, I'm not taking big money. I'm not going to do it. I think it's wrong. I I will be able to sleep at night, and if I'm elected to the Supreme Court, I won't have to recuse myself. So I'll be happy with that.
Judge Riley.
Basically, your question begs the merit selection versus elected, correct?
That's one way to look at it. Mhm.
I'm a candidate. I'm an election. I like the election process. Merit selection, if it was merit selection, the Supreme Court's already spoken. They know who their candidate is. The bar associations have given our highest ratings. That would be merit selection. We would never have this process that you see here. You would never have the 5 of us up here putting forth our credentials and having you judge us. You're going to let 7 people who you don't even know, haven't seen, make that decision. I don't think that should ever happen. So is it expensive? Yes. Are there downsides to it? Yes. Maybe one thing is Cook County is such a huge place. How do you get your message out? And it's expensive to get that message out. Maybe we should bust Cook County into 3 districts and still have our 3 judges, but run from smaller districts. And maybe you could handle it with less money and less input from campaign donors. That's about the only way I see it.
Thank you. Justice Cunningham.
Well, obviously, the large amounts of money that's raised and spent in campaigns is of concern to everybody because you need money to get your message out. What's the best method to do it is something that remains puzzling to all of us. But I will say, rather than spend my time thinking about would I prefer merit selection both over the elective system, I think we have to work with what we have. And what I choose to do is to try my best to maximize the system that we have, to get my message out to the voters and to try to communicate as much as possible to all of those people who will be voting, who I think would be receptive to the message that I have to bring. Whether or not public financing would be the best method to do that is something that I really haven't thought about, and I'm not prepared to take a position on that. But I do agree that the large amounts of money that we see being raised in judicial elections really do call into question lots of things, transparency, integrity, et cetera.
Thank you. Justice Tice.
I'm sorry, David, but I have to say this. Talking about merit selection, I think, is really not the answer. In that I've studied every system every state has. And in every system, including merit selection states, judges at some point appear before the public. We saw that in Iowa, where 3 judges were defeated in retention, even though they were chosen in merit selection system, because of their unanimous decision in the same-sex marriage case. So I don't think that's the answer to all of these things. I do think that we have a big issue about third parties, the whole Citizens United idea. I believe we need to have new rules in Illinois for the kinds of campaigns that are not like the campaigns we're running, but is it really only, that was a minute? I'm sorry. I didn't think that was, okay, sorry. I think there should be new rules.
And was that, as a follow-up to that, is that a reference to the independent expenditure campaign that I know you've talked about regarding Justice Kilbride's election as an example and others? Or are you talking about something outside of the judicial sphere?
Right now I'm focused on the judicial sphere, and I think what we've seen, so we can just talk about what we're saying, instead of campaigns like all of us are running, where we're going to our friends and asking them to support us, what we've started to see around the country are third parties coming in and pouring huge amounts of money into judicial races. That's what happened in Iowa, that's what we saw happen here, and I do think that changes the landscape of our judicial elections. The American Bar Association and certainly in many other states, Sandra Day O'Connor, have called for changes in ethical rules in response to this. I'm very interested in the rules that the Supreme Court of Tennessee recently adopted, and I will, when I go back to Springfield, be asking my colleagues to look at some of those new rules to respond to this new landscape.
Thank you. Let's move on to the next question. I'll start with Judge Riley. Have you experienced or observed discrimination, bias, or intolerance based on race, ethnicity, gender, religion, or a similar category? And if so, how has it affected your judicial philosophy or your views as a judge?
I have witnessed some discrimination while I'm on the bench, usually amongst family members, not amongst my colleagues, and not amongst necessarily the lawyers. When you deal in probate court and you bring these families together, there are families that do not get along, and they openly display their own hostilities and their discrimination. Much has to do with a lot of sexual orientation issues. who they marry outside the faith, and these scars are not within us, they're within the people that appear in front of you. So my efforts are used to diffuse that, to get through that and get down to legal issues the best I can, and not allow that to boil over and to have any precedence in my courtroom.
Thank you. Justice Cunningham.
Well, certainly as the only African-American candidate standing here, I can tell you certainly I have experienced discrimination, certainly as a practicing lawyer. And I think I've always used it as a teachable moment because I believe that people really don't want to discriminate. A lot of it comes from lack of knowledge, ignorance, whatever you want to call it. But I always try to use that moment as a teachable moment.
Good. Thank you. Justice Tice.
Well, I was a public defender back in the bad old days. I remember very clearly where race was a given in the decision-making in terms of preemptive challenges in juries. I represented many African-American defendants and who faced all-white juries over and over again. When the United States Supreme Court finally brought this issue to a close, we hoped, in the Batson case, by then I was a judge. I've handled a number of cases on the appellate court in terms of making sure that our juries, in fact, reflect the community. And I think it's a two-part piece. One of it is the defendant's right to have a jury that reflects the community. But I also think it's the right of the community to have jurors who can, in fact, make decisions that we all can believe in. Because if we are, if the validity of the jurors' verdict is tainted because of that kind of racial discrimination, then that threatens the confidence in our entire system.
Thank you. Mr. Flanagan.
Yes, growing up on the South Side, going to school at Mount Carmel High School, I saw examples of discrimination, and I heard about examples of discrimination from my colleagues and classmates. I think that opened my eyes to some things that I didn't know before I had actually seen it firsthand. I do wish there was something I could do that would make this go away. I haven't quite figured out what it is. But I do think that organizations like the ADL and other organizations that try to draw attention to unfairness and discrimination are playing a very important role. I think that they face something of an uphill task too, but at least they're trying. And I think that there's always something to learn about other races, other cultures. I've traveled around the world 14 times, and the things I've seen in other countries makes me think that maybe the United States really isn't such a bad place compared to some of the countries I've been to.
Thank you. Justice Paczynski.
I went to college so long ago that when I applied to Georgetown, I was told I couldn't get in because I was a girl, and unless I wanted to be a nurse. My first case that I heard after I became a lawyer in Illinois, the judge said, "Hiya, honey, how you doing?" And so, I think, yes, the answer is, of course, anybody that has practiced law for a long time has either seen some form of sexism if you're a woman, or abuse or whatever, and also has tried very hard in the practice of law in our communities and in my courtroom specifically to make sure that it did not enter the doors of the courtroom. So my focus has always been to make sure that based on my experience with the community, with my family background in ethnic radio, for example, which was fabulous because I got to meet a lot of different communities that way, I look at every case in a really a justice is blind sort of way and try to make sure that everybody else is doing that. And I think that's the best you can do as a judge, as an attorney also. But yes, part of that has been informed by my own feeling that certainly when I was a young lawyer, people were hostile to women lawyers. People just didn't see why women were being lawyers, and that has made me, I think, very sympathetic to a lot of things. And growing up in Washington in the 60s, having a chance to see Martin Luther King and the civil rights activities and legislation was a fabulous experience.
Thank you. Very quick follow-up, 15 seconds. Judge Riley.
Yes.
Should the diversity of the court play a role in a voter's choice in this election? Yes or no? With a very short explanation.
No, I think qualification should,
Justice
and work
Cunningham.
ethic.
Justice Cunningham.
I think qualifications are foremost, but I think qualifications and diversity both have a role to play, but qualifications certainly are foremost.
Justice Tice.
I think it depends on how you define diversity. We each bring a different voice, a different experience, and I think that is important, that the court reflects all of the different kinds of stories that you've heard here.
Thank you. Mr. Flanagan.
Qualifications are most important, absolutely. But this is the beauty of having judicial elections, that if people don't agree with that and they want to take that into account in who they vote for, that's going to be evidenced at the ballot box.
Justice Paczynski.
I think the qualifications clearly are the most important, but diversity is also critical, and that's why we have sub-circuits in Chicago and Cook County. I think that that has helped. I think that the process of associate judges, I think the Supreme Court could perhaps weigh in a little bit more persuasively on how the associate judgeships are used to plug in some of the diversity gaps in Cook County, and I would like to be active in that.
Thank you.
If voting for a Republican counts as diversity. I want to
Well
change my
said.
answer.
That's well said, especially here in Cook County, no question. Next question, I'm going to start with you, Justice Cunningham. I'd like to explore your views on corruption, and I'd like to do that by asking about one of the biggest judicial corruption scandals in our country's history, known as Operation Greylord. In the early, and I'll note that when I teach this at the University of Chicago Law School and everyone's in their 20s, it's like teaching some sort of, and not from Chicago, it's some ancient foreign history. In the early and mid-1980s, through a series of federal prosecutions, it became known that a substantial number of Cook County judges had been fixing cases, and in some instances, the cases included outfit murder cases. Overall, 15 judges and many others involved in the court process were convicted. And as students of Chicago history and those who remember Carl Sandburg's poem, Chicago, know this type of judicial corruption had been going on for decades. Here's the question. How did this happen? All of you were young lawyers at this time. Some were just starting to practice. Justice Tice, you had been practicing as a public defender at 26th Street in the 70s and in the early 80s and were elected to the bench in 83. Justice Paczynski, you were a practicing attorney and involved in politics in the 70s and early 80s and won your first election in 1984. All of you have different perspectives. But all of you were observers of this tragedy. What caused it? A corrupt political system, the failure of judges and lawyers to speak up, a citizenry numbed into accepting corruption? Justice Cunningham.
I think it's a combination of all of those things. You know, the recent article that named Chicago the most corrupt city in the country really, I think, is kind of a badge of shame for all of us who live here to some extent. So I think it was a combination of tolerance, of practices that people knew were not right. I was not practicing during those years. I was a brand new lawyer, but it's one of those things where people went along with the system because it had always been in place. And sometimes it takes courage to step outside the box and do something different when you know everybody else is going along with whatever existed that you knew was not correct. And I think that the crashing down of that system finally came about because somebody had courage. And how it happened, I think it was a combination of all the factors that you mentioned, and it took courage to break the system.
Justice Tice.
I became a judge on July 1st, 1983. It was one of the most happy days of my life. About 6 weeks later, it became clear that the federal government was investigating the judiciary. It stung me deeply, personally. How could judges, people who had taken the same oath I had just taken, have done this? This breach of faith with the public, how could this have happened? I vowed then to dedicate the rest of my public life to healing that breach of faith. Now, I believe part of it is, yes, people didn't speak out. I was only a judge for 6 weeks when this happened. But I immediately began to teach judicial ethics. We formed the Illinois Judicial Ethics Committee to be able to give advisory opinions to judges so that this would never, ever happen again. Every judicial program that I've ever planned has an aspect of judicial ethics to it. This was the most horrific scandal for people like all of us who have taken an oath to uphold our law.
Thank you. Mr. Flanagan.
Now, older Chicagoans in this room will remember Len O'Connor, a political commentator who used to say the way the party worked in Cook County was, I don't want to see nobody that nobody sent. Now, that's local English, but it also shows how the crony system worked in Cook County. I'm not blaming everybody in the party, I'm not blaming all the candidates, but in a way, judge has become the ultimate patronage job for people that have come up through the system, supported it, and then they're rewarded at the end of it. Not all of them, but I do think this is part of the problem. There's sort of a locked-up political process. My wife and I got our own signatures to get on the ballot this time, as we always have. We approached about 30,000 strangers to get 13,000 signatures for the two filings. And we got an earful about judicial corruption and corruption beyond that. People like the idea of judicial elections, but they don't like the idea of it being anointed from on high and nobody can beat it.
Thank you. Justice Paczynski.
I became the clerk of the court right after the Solovey Commission issued its report, and one of the first things I did, as a matter of fact, the first memo that I sent to the clerk employees, several of whom were indicted, as you recall, was to send out a memo attaching the criminal code saying absolutely no gratuities, no gifts, no envelopes, nothing. No clerks will accept any of that. If you're caught, we'll send you to the state's attorney's office. And that day, 4 clerks came in and quit because they couldn't afford to live on the clerk's salary, which told me that this was a good step to take and something that I took very seriously as an administrator. As a judge, I take it very seriously. I take my oath very seriously. And the reason it happens is greed and cozy relationships between clerks, between judges, between sheriffs, between political appointees and the guys who made them, the made judges. It is a failure of the system. It's a failure of voters to hold parties who, if they're going to endorse candidates, responsible for endorsing quality candidates. I mean, why did the Democratic Party re-endorse Blagojevich when he was being under investigation? You know, you have to ask yourself these questions. Why is Joe Barrios picking judges? I like Joe Barrios, but why is he picking judges?
Thank you. Judge Riley.
An interesting statistic that came out of the Graylord investigation that seems to be passed over by everybody is that 85% of the sitting judges that were sitting on the bench during Graylord came from the public sector. When Mr. Flanagan said they come up through the system, that's exactly what they did. Their bad acts were not just earned on the bench. They were engaged in that before they ever took the bench. That was the gist of Graylord, and nobody seems to care about. There's only like 12 or 13% of us in private practice that has ever run for the bench. And that's a direct result of those statistics. So if you keep electing your public defenders, your state's attorneys, your corporation counsels, your park district employees, those were the people that made up the bench back then and probably still make it up today.
Thank you. Next question, I'll start with you, Justice Tice. One of the crises in our judicial system today is the big decline in access to the courts for low-income people.
Courts what?
Funding for the U.S. Legal Services Corporation has been cut substantially, and funding from interest on trust accounts has declined as well, which means that legal aid organizations are laying off lawyers and other workers in big numbers around the country. As a result, fewer people of limited means can get access to a lawyer. What is your perspective on this crisis, and what are your thoughts about how we solve it?
This is my number one issue, is access to justice, because I've seen it over and over again throughout our court system. In the past, we've talked about this in the sense of poor people. We've addressed it in ways of, for example, of funding for legal services. And we know, as you've indicated, David, that those funds are being cut back. But I do believe this is a growing problem that's going into the middle class as well. Now, there are a number of things that we can attempt to do. One is to encourage lawyers to continue to do volunteer legal services. I wrote the rule that requires all of us to report how many hours of legal services you do once a year. And the purpose of that is to encourage you to do so. Since I wrote that rule, the number of hours that Illinois lawyers have, pro bono work that they have done has gone up to 2.3 million hours a year. But I think we need to do more. When I am elected and retained on the Illinois Supreme Court, one of my first goals is going to be to urge the rest of the court to create an Access to Justice Commission. Most states have that, a way to holistically look at this problem, because I think this is the number one problem we have in our court system today.
Thank you. Mr. Flanagan.
I think this is a problem, and it's a very difficult one to address, mainly because the state is broken. We can't just throw public money at it. A couple things I've thought of would be to possibly have fewer restrictions on law students and law clerks helping indigent people. When I first started working in a law firm right out of college in 1974, back then people were appearing in court all the time, whether they were lawyers or law students or not, at the lower cases. After that, there was a lot of crackdown on that. But there's a lot of people in law schools now who can't get jobs, who are idealistic and they need hands-on experience. They should be supervised. They must be supervised. But they can help poor people, either through a legal clinic or an expansion of existing programs within the circuit court. The domestic violence branch actually has a lot of law students there every day helping people. Why can't we do that in other divisions?
Thank you. Justice Paczynski.
I would also like to expand the work of pro bono activities among lawyers. Not every lawyer is going to be able to handle every kind of case, and so you have to have some sort of management of that process. I understand that, but I think that being more robust in your urging to get lawyers to do pro bono work is important, and setting up a process for them to find a way to do that, as we have in Chicago. We have a committee, a pro bono committee, that operates mostly with the big firms, and it works very effectively, but it doesn't really reach out to the solo firms or the small firms, and I'd like to see that happen. This is a middle-class problem as well as a problem that affects people who are in in poverty. The middle class can't afford expensive lawyers, and so if somebody screws up their roof, what are they going to do? It's hard for them, and so we obviously need to find a way to get more lawyers involved in the process, but we also need a way to speed up the process, because access to justice is not just trying to throw more lawyers at the courts, but also to make the courts more efficient, and that's where I would deal with allocation of resources and faster discovery.
Thank you. Judge Riley.
Access to justice has been an issue that's been tossed around for a long time, and lawyers have spent years actually doing pro bono work. Many of the small firms and solo practitioners that I know are actually hurting themselves. And to reach out into that community and start tapping it for even more service is going to be hard to come. In every jurisdiction in the United States that's been faced with these draconian budget cuts, they had to turn to the computers, and they get to what they call paperless filings. And that's what I see here. It's actually driven by the lack of funds. So if you want to access the courts, it's going to have to morph into some type of computerization, because there's only so many lawyers, there's only so many clerks, and the clerks are being decreased, access to the courtroom is being decreased. They're going to start cutting everything. The only way around these cuts is to do something alternatively. I don't think it's ever going to go back to the way it used to be. So we have to actually change something here, and that change appears to come in the form of computerization and access to the courts through that system.
Thank you. Justice Cunningham.
I think that the access problem continues to be an issue. When I was a young lawyer, which seems like a long, long time ago, it was a problem then. I did a lot of pro bono representation of people who had been denied Social Security, kicked off of the Social Security rolls. That seems like nothing, but those people are in between any kind of safety net. They need someone to represent them at an administrative hearing, but who's going to do that, because there's no money in it? So those are the kinds of things that I think you have to look to organizations such as the Chicago Legal Clinic, an organization on whose board I sit. Now that I can't personally represent people anymore, I think it's very important to support organizations that bring access to those who can least afford it. So the Chicago Legal Clinic, the Chicago Volunteer Legal Services, the Center for Conflict Resolutions, those kinds of organizations I think ought to be supported with more funding so that they can do what they do best.
Thank you. I think we have time for about 2 more questions. I'm going to start with Mr. Flanagan. We're going to go back to this issue of disqualification/recusal and elected judges. Allowing substantial campaign contributions in judicial elections creates difficult issues on these topics. Just before Citizens United was decided, the U.S. Supreme Court held in Caperton that a huge independent expenditure campaign in West Virginia to elect a justice there on the Supreme Court created an unconstitutional bias for that justice that required his recusal from a case involving the main contributor's company. The issue of objective standards for recusal is going to increasingly become an issue after Citizens United and the recent ABA proposal on this topic. And the concern is not just about campaign contributions, but about close relationships that create bias. So I want to ask you, all of you, a hypothetical question to try to flush out your standards for disqualification. You are elected to the court. A fellow justice comes to you with a recusal question. His wife is a well-known, successful private equity investor and is known to be the lead investor in Company A. Company A is trying to do a hostile takeover of the Midas Touch Corporation. But recently, Company A's main competitor, Company X, also announced its intent to effect a hostile takeover of Midas Touch. Quickly, a group of individuals, including some shareholders of Midas Touch, sued Company X, alleging state law violations that would knock it out of the hostile takeover competition, and it's rumors the plaintiffs are associated with Company A. The trial court ruled for the plaintiffs, so Company X is now knocked out of the competition, almost certainly clearing the way for Company A to succeed in its hostile takeover, but Company X has now taken an expedited appeal, and the matter is quickly headed toward the Supreme Court. Should your colleague hear this hostile takeover case, or should he disqualify himself because of his wife's close ties with Company A?
I think that it's a case for disqualification, and I'll tell you why. The standard for recusal, even before any reforms, has always been pretty high, and a judge is held to a much higher standard than a private attorney in the appearance of impropriety. An additional reason to have a strict standard on this is the growing feeling among the population that there's a corruption in the judiciary. Unfortunately, Graylord did not dispense with all of it. It helped, but it's still there. And you don't want the public to have any more reasons to distrust the courts than they already have. Now, when I clerked for the Illinois Supreme Court, that was 28 years ago, I was amazed how often the judges were recusing themselves then. And I talked to Justice Clark about that, and he was very sensitive about it. Anything that even got close to a situation where there could be somebody accusing a judge of impropriety, that was it. He didn't spend 2 seconds thinking about it. And what has happened since then makes me think that we have to be equally vigilant, if not more vigilant now. When in doubt, recuse.
Justice Paczynski.
That's the standard that I use. If the question even pops into my head, then I recuse. Now, that's a luxury. If you're on the circuit court in Cook County, you've got 400 other judges. Somebody else could do this case. If you're on the appellate court in Cook County, you've got 23 other justices. Somebody else could do this case. On the Supreme Court, there's only 7. So all of a sudden, the numbers are really small. And to recuse yourself is a very serious proposition.
How about the hypothetical?
I'm sorry?
How about the hypothetical?
In the hypothetical, I say yes, absolutely disqualify yourself, get out of it, because the appearance is the problem. If people don't have confidence that the system is fair, that it's above board, that everybody's getting their side of the story on a level playing field, then the system isn't working. So you've got to do that. But on the Supreme Court, as I said before, I think one of the ways to do that, especially in a campaign mode, is to stop the problem before it begins, and then you don't have the problem.
Judge Riley.
When in doubt, recuse. Given the hypothetical, the first question I'd want to know is how did the fact that the guy's wife even worked for the equity get out? Did he disclose it himself?
Publicly known.
Publicly known? Recusal.
Okay. Justice Cunningham.
Well, I think it's important to avoid the appearance of impropriety because, as one of my colleagues here said, if it looks bad to the public, they probably will just assume it's bad. So, in my view, when in doubt, recuse yourself. Nothing can be gained by sticking it out. Recusing, I think, would be
How about the
answer.
hypothetical?
I think recusing yourself, recusal would fit in my view.
Justice Tice.
When I teach judicial ethics, I present it to the judges this way. We need to always be looking for red flags, asking ourselves the question. Maybe we'll answer it one way, well, maybe we'll answer it a different way, but we should always be on the lookout. Where are those areas that someone, because that is the standard, this objective test, someone from the public could question a judge's integrity? Now, I think this one is, from the way I understand your facts, I think this one's pretty easy, because I think it's more than just this general sense of the objective standards of the public question impartiality. The Supreme Court Rule 63 requires a judge to disqualify, is really the term of art, if a judge's family member, the wife here, has more than a de minimis personal interest in the lawsuit. And the way I'm hearing your facts, it sounds pretty close. So it seems to me this is an easy call. It falls right in the rules, and the judge should recuse.
So quick follow-up question for everybody, starting with Mr. Flanagan. In light of your answers to that hypothetical, should Justice Burke have recused herself in the Rahm Emanuel residency case?
Well, you asked some tough questions today.
Thank you.
In my heart of hearts, I thought she should have, but I think I can see why she didn't and why people can justify it. Very briefly, that wasn't a financial issue. And I also think that I don't know of anything, I haven't heard of anything close between Alderman Burke and Rahm Emanuel in terms of their own alliance or
Well, just to
friendship.
refresh, in that case, her husband, Alderman Burke, had endorsed one of Rahm Emanuel's primary opponents. And so the question is, if the hypothetical doesn't apply, and you may have suggested an answer there, how do you distinguish the hypothetical?
It's not easy to distinguish these things. I mean, when you have somebody as powerful as Alderman Burke, and you have his wife in the Supreme Court, and you have a very tough once-in-a-generation case like this, no matter how you decide the issue, you're going to offend people. I can't really criticize her for doing it, but if I had been in that situation, I would have recused myself.
Justice Paczynski.
I'd like to start by saying anybody who knows Justice Burke knows that she is independent and makes up her own mind. I doubt very seriously that Ed Burke is able to tell her very much what to do about anything. That being said, I think that it was a very serious question for her, and I'm positive that she wrestled with it and came up with a decision that she was comfortable with. There are other issues, though, that come up with recusal, and so, you know, in that specific case, there were other individuals that could also have been asking themselves serious questions about whether or not they should recuse themselves, and they did not. And so I don't think that it's all just one justice that was at question here.
What do you mean by that?
I'm sorry?
What do you mean by that?
Well, I think it is fair to say that one of the justices on that panel is a neighbor of Rahm Emanuel's. And, you know, that wasn't disclosed. And so somebody could question that, as well as questioning whether or not, you know, your husband knowing the guy, even though they were tangling at the time, is important. This is a political process. Every justice is going to make their own decision. Every justice is going to have to weigh the decisions, knowing that it is the appearance of what's going on that is almost more important than the fact of it, because when citizens see these things, they get very disturbed and very cynical.
So should neighbors always be recused?
I think that would be up to the individual justice.
Judge Riley.
Ann Burke went up to the Supreme Court completely unopposed at the primary or the general election. Shame on everybody here in the room. That never should have happened. Never. So should she have recused herself in that political case? Absolutely.
Justice Cunningham.
Well, I'm not so sure that Justice Burke should have recused herself because her husband happened to have supported a candidate that was an opponent. My husband doesn't tell me what to do, and I think it's very safe to say that I think Justice Burke is her own person. And given the small number of justices on the Supreme Court, I think that's a close one for me. But I come back to, if it makes you uncomfortable and there's an appearance of impropriety, the prudent thing to do is to recuse yourself.
And so how do you distinguish the hypothetical where the justice should recuse himself? In the hypothetical, the justice should recuse himself, but you were comfortable with Justice Burke not recusing herself. How do you distinguish the two?
I think it depends on the facts of the case, the individual facts of the case. And if there's an appearance of impropriety, a lot of people seem to feel that there was an appearance of impropriety there. So in this situation, I think Justice Burke could certainly not have gone wrong had she recused herself.
Justice Tice.
I am very proud of how the Illinois Supreme Court handled that case. We received the petition for leave to appeal on Tuesday morning. By Thursday afternoon, we had issued a unanimous decision. It was very important, given the public nature of that case and also the pressure of time, that it was handled the way in which it was. I'm not going to comment specifically on that case because I participated in that case. I've written on it, or I don't know if I've written, I signed I concurred in the case. So I'm not going to specifically comment except that I am extremely proud of the manner in which the court handled it.
Let me just ask this follow-up then, which is, you know, very, very fair answer, but just in terms of the general standards for judging disqualification when it moves from the financial hypothetical that I gave to the issue of people who are political supporters in one way or another, either as contributors or endorsers. Justice Tice, how would folks here, how would you describe your general standards for judging those issues going forward?
Well, first of all, we understand this is a political system. That's the nature of the system that people have chosen. And I believe that the people of this state are comfortable with the system that we have. Now, we could change it perhaps, but I think the people's confidence is not shaken by the fact that judges present themselves as candidates. Now, I heard one of my opponents today say two things. One, that judges should be nonpartisan, and two, that she would limit her campaign to $500 contributions. Last week, she received two $10,000 contributions, which are both above her caps and are illegal. And secondly, she chose to wade into a partisan election and make an endorsement. In my entire career, I have never seen a judge do anything like that. Now, to me, those are questions that raise the issue of whether or not the public has confidence in the integrity of the judiciary.
Justice Paczynski, let me let you respond.
Sure, absolutely. I received 2 $5,000 loans to my campaign, which I've signed a promissory note to repay personally. And it is true that my treasurer mistakenly deposited $10,000 personal checks, but we refunded the extra $5,000, so that was immediate as soon as we realized the mistake. But my campaign contribution limit, what I don't have to pay back, is no more than $500, and I'm sticking to that. Now, for one of my colleagues to say that she's proud of the way the Supreme Court handled that decision was ripe with uncivil language. It badgered the appellate court justices who were in the majority, and I look at the concurring opinions instead and say that was really the appropriate way to do that. Political endorsements, I'm going to tell you what, one of my colleagues is endorsed by the mayor of the city of Chicago, strongly endorsed, raising money for her, helping her, walking her around, taking her places. Every time the city of Chicago is in litigation, do you know how many times the city of Chicago is in litigation? And with all due respect to my good friend and colleague, Justice Cunningham, she's been endorsed by Tony Preckwinkle. Do you know how often Cook County Hospital is sued? So I think before John Stroger, the old Mayor Daley, the new Mayor Daley, they didn't endorse in Supreme Court races, and that's why.
So I just have to ask one follow-up question. One of the things that Justice Tice mentioned was your endorsement of a candidate in a separate non-judicial race.
Yes.
And there's been some criticism of that, and you've defended yourself by saying that was perfectly appropriate. Can you explain how that was appropriate under the judicial canons?
Well, in the first place, we're allowed to endorse if we are candidates under the canons. And so I'm happy to take an advantage of that in this particular race. The clerk of the court race, where Rick Munoz is running against Dorothy Brown, who's made a mess of that office. And I was the clerk of the court for 12 years, and I ran a good office, 12 years without scandal, and I understand it. So in terms of the technology, the budgeting, the resource allocation in that office, I'm very comfortable endorsing in that specific office for that reason. I'm not endorsing in state rep races. That's not my deal. But in that clerk of the court race where I was the clerk of the court for 12 years, yes, I think they need a specific change, and I think I'm happy to have endorsed Rick Munoz.
Thank you. Well, let's leave it there and go right to concluding remarks. Let's go in the reverse order from the opening remarks. So, Justice Tice, we're going to start with you and then come back this way. And we've allotted about 1 minute per concluding remark, so please try to respect that limit. Thank you.
I certainly will respect that, because I do want to thank all of you for being here. We talked a little bit about the manner in which we choose judges. And certainly, we could always reform the system we have, but this is the system we have. And I believe the most difficult problem we have with our system is that it's hard for voters to know who they should choose for this important role in our society. That's why a meeting like this today is so important, because you've had an opportunity to hear who we are, the things that are important to us, and hopefully you'll be able to tell your friends and your colleagues about what you've seen. I'd like to once again urge you to consider my candidacy in this way. I am by far the most experienced judge here. I have dealt with every level of this court. Over and over again, my credentials have been evaluated. The Council of Lawyers called me a scholar of unquestioned integrity. I ask for your support. I've been sitting on the Supreme Court for 1.5 years now. This is not just a job for me. This is not career advancement. This is my life's work, and I ask for your support.
Thank you. Justice Cunningham.
Thank you. Thank you all for being here, giving up your lunch hour to listen to us. I agree with the Council of Lawyers' assessment that the Supreme Court should have justices who bring broad experience to the court, and that's what I bring to the table. I have sat on every level of court. I wasn't fortunate enough to get appointed to the Supreme Court, so I haven't sat there yet, but I've been a trial court judge, I've been an appellate court judge, I have practiced law, I've tried many, many cases. I've been involved in judicial education, in legal education. I have significant administrative experience, and I have significant life experience. I think it is very important to bring diversity of practice experience to the courts so that the court is reflective of the population that it serves. I think it's extremely important that our Supreme Court justices come from the people and are of the people, and that the system presents to you justices who have integrity, independence, and legal knowledge, and that's what I bring to the table, so I ask for your support. Thank you.
Thank you. Judge Riley.
I think my most important quality is that of balance. 15 years as a private practice, self-employed, 15 years as a judge. I haven't been indoctrinated in anything. My background goes to every facet of the law, not just criminal law. Civil cases, criminal cases, misdemeanor cases, juvenile cases, the depth across the board. One slogan we had when I was running 15 years ago is that lawyers ought not retire to the bench. Judges should retire from the bench, not to the bench. I was 42 when I ran then. I'm 58 as of Saturday. Thank you. And and I still got, it's a 10-year stint on the Supreme Court. So I go on at 58. Thanks for your support. And I'll come off when I'm 68 after 10 years. You know, I think age is a factor. You know, you bring to it some energy, you bring to it some new thoughts, and you're not indoctrinated into the Cook County system in any shape or form.
Thank you. Justice Paczynski.
First, I'd like to thank the ADL for having us today and for all of you for joining us. And I hope you'll invite us back in 2013 when you celebrate your 100th anniversary, because I think that will be a wonderful experience for all of us. I have never been appointed a judge. I have run for judge, run for election, and I'm very proud of that because the citizens of Cook County have recognized in me my experience, my work ethic, and my diligence in working on their behalf. I have administrative experience, which is important in terms of technology, budget, resource, contract negotiation, which is about a half of the Supreme Court's job. I'm the only independent on the Democratic race in terms of the 3 women who are running, because I did not ask for the endorsement of any big politicians or the party, and so I'm not tied into anybody. I can walk in the door and say, I don't owe this to anyone. I'm my own person. I have got experience. I was a trial lawyer. I've worked in different agencies. I've been a trial judge. I heard 10,000 orders of protection. Those are hearings. Those are trials. And other kinds of cases as well. So I bring experience as well. My goals would be to expand mediation, make this court system accessible to seniors and the disabled, to finish up the technology projects that are now pending, and to make youth peer juries something that happen across the state. And I ask for your support. I'm Aurelia Paczynski. Thank you.
Thank you. Mr. Flanagan.
I'd like to thank you all for coming out again. I was wondering what would happen if they have an election that's important and nobody cared, nobody showed any interest. But look at all these people here. Some people are interested in it. I think we all feel deep down that there's something bad about judges who are running for office accepting contributions from other attorneys or from other interest groups. And you don't get a chance very often to vote for a candidate who will not take contributions. You have a better chance of seeing Haley's Comet than to go into the voting booth and have that opportunity. So this is your chance. We're beholden only to justice. There's no strings attached. If we get a check in the mail, we send it back. These are good candidates. I know I'm an underdog in this race, but sometimes miracles happen.
Thank you. You know, sitting from my viewpoint here for the last hour and a half watching this, it's quite an extraordinary thing. We've probably all been to various candidate forums. I know I've been to a few. But judges are different, and the judiciary is different. And the idea that these extremely talented folks come here, some of them off the bench, to answer these questions under also something that's quite challenging, as I've experienced, the 1-minute time limit. Folks, that is not easy to do. And I just think it's so fantastic that all of you came, but most of all, I want to reserve the thanks for the candidates. It's an incredibly impressive group. We're very fortunate that everyone came here, including the ones who are judges, and answered our questions. And I want to give them all a very warm round of applause. Miriam has a couple of quick wrap-ups things, just some administrative notes. Please leave your lunches at the table. Your instinct will be to help and to clean up, but it'll actually be easier for the staff if, and they've asked me to ask you this, if you leave it there. And second, please be relatively quiet on your way out. school is in session here at Sidley, and people are working all around in the conference room, so quite we appreciate it. I appreciate you being such a great audience and great candidates. Thank you very much. And here's Miriam Lieberman.
I just want to say thank you again to our moderator, David Hoffman, for doing such an excellent job here. And I want to echo his thanks to all the candidates for dedicating their time, effort, and energy to being here and sharing openly and honestly answers to the questions that were posed. This is really an excellent opportunity to learn about their backgrounds, their experiences, and their views. And it's really been an extremely enlightening and informative experience. So thank you all for being here. We hope you've enjoyed the experience.